Welcome, everybody. If you are able to, please turn on your camera. Those of us who are teaching, it's so much nicer to see smiling faces than a little square with your name. Even frowning faces are a little better than smiling faces. Hey, Alfonso. Alfonso's got his camera on. The camera's on, please. We have an interesting topic today. We're going to hear about common contract complications. That's kind of a mouthful from Universal Title. And we have Logan here to start teaching this. And so, if you have questions as we're going through this, raise your digital hand if you don't mind. And that way, either Logan or I will probably notice it so we can answer it. And please turn your cameras on. We really appreciate it for those of us who are teaching. And I will take it away, Logan.
Alrighty, yeah. Hi everyone. My name is Logan. I work for Universal Title. More specifically, I work out of our Capitol Hill and Bethesda office and as a part of our business development and sales team. But I really only work with our KWCP agents. That's who I work with. I don't know if I should say, I see some familiar names and faces on the
Right.
call. So, hi to everyone who I know, and then it's nice to meet everyone else. Um, who's going to really be leading the bulk of the class is our attorney who sits out of the Bethesda office, Joseph Bruno. He's going to be joining us in just a second. He's running a little bit behind. He had a closing that ran a little bit longer than usual. So I'm going to be starting off the class a little bit. So, before we jump into Joe's topic, I'll talk a little bit about Universal Title. So, we are Keller Williams Capital Properties in-house title partner. And I know a lot of you guys are newer agents, and title can be a somewhat daunting topic and something that not many people are very familiar with. Going into the industry, even I wasn't very familiar with title insurance when I joined Universal Title. Um, so if you have any questions, feel free always to reach out to both Joe and I. All the KW team has my contact information. You can find my contact information on Universal Title's website. Also, my information is always provided at all of the team meetings for DC and MoCo. Um, so, a little bit about what I specifically do. I mentioned I was a part of the business development and sales team. And what that means is I'm really able to work with you all to help potentially sponsor an event. We just recently worked with Alfonso and Emmanuel and Kalana, and they had a really successful event just last weekend where Joe spoke. But then leading up to the event, I worked closely with Alfonso, Emmanuel, and Kalana. And those are the sort of things that we can help out with. In addition, I know Keller Williams has so many resources, but we also have some resources to offer. We send out market stats once a week. And then additionally, we can help with farming report. And one initiative that us as a team at Universal Title is really, really working towards and striving, and a big part of my role right now is learning is working on our social media team, is working with our social media team. And so what that means is our hope and our attempt right now, we're in the process of doing so, is to create some social media spaces for you all to be able to sign up and then hopefully able to use and film content for your social media. Um, in order to do that, obviously, like reach out to me. And I'm also happy to help work with you guys on your social media in the interim. We're also working together with Harmony, who I'm sure all of you guys know, to hopefully get some work with you guys on some content days. And we're really excited for all these initiatives. But like I said, in the interim, please feel free to reach out to me and I'd be happy to get something on the books, whether that be about social media or farming reports, um, sponsoring an event, whatever that may be, whatever concerns you have, or if it's just a title question, feel free to shoot me an email or give me a call, and I'd love to schedule a time to meet with you all. I'm gonna go ahead right now, and I in the chat will put my email and my phone number for you all. Um, .com. And it looks like that is great timing. It looks like Joe has just joined. So I will go ahead and let Joe introduce himself and talk about some contract complications that may arise.
Great.
Hey everyone, thanks for having me. My name's Joe Bruno. I'm the attorney and manager for our Universal Title Bethesda office. Kirsten, I was just closing a deal for Nicole actually, so we ran a little bit late, but we did get one closed, so we're always happy about that. So sorry about I was running a little bit late, guys. Why don't I go ahead and share my screen and then we'll get started. Screen share. Good. You guys can see my screen okay? Yes, seeing nods.
Yes.
All right. Thank you, Alfonso. All right. Way I like to run my classes, if you guys have any questions, put them in the chat box or interrupt me. That's fine as well. So the more questions we get, the better. Today's topic is going to be from contract to close, some of the common errors that I see on contracts or during a closing, and how do we navigate those issues when they come up. I am an attorney licensed in Maryland, licensed in DC. I'm not a Virginia licensed attorney. However, I am a title producer in all three jurisdictions. As many of you guys know, I can close in all three jurisdictions. I work primarily with our KW Bethesda team over here. And then I know a lot of you guys also work with Ryan as well. He does a fantastic job. He can do Maryland files. I don't think he does Virginia though, but I'm sure I'd be happy to walk him through if that ever came up. So to get us started, I think we need to think about what are the things that are in control of the real estate agent and what is not, right? You can't control an issue with the lender. You can't control an issue with title. You can't control a home inspection issue. But what you can control is how we communicate these issues when they come up. It's so true and such a cliche, but communication is key. And it is a two-way street. Us at the title company, when there's an issue, if something's coming up, I'm going to let you know. We're going to communicate it as soon as we can. And from my perspective, when we're communicating something that is happening during a transaction, I'm not just going to land a problem on your feet. I'm hopefully going to give a solution to you as well, or figure out what are the same ways we can solve this problem. Yes, there's some constraints on that in that I can't give you legal advice. I can't give your client legal advice to the disadvantage of another party, but we can talk through some of the common solutions that I've seen to handle different types of issues that come up. I obviously can't negotiate on your behalf, but we can usually brainstorm things like how do we get this done? And I'm going to talk a little bit about the specific context in which that makes sense. Chat box, there it is. Good. Moving to the next slide here. Let's go over the settlement process. I think, especially for you guys, if you've been in the industry under 2 years, it is so helpful to understand what is happening behind the scenes at Universal Title. I think that just helps a lot. I'll be honest. One of the common things I hear is, oh, my clients never got the wiring instructions and they're freaking out about it. I promise you, your clients have gotten the wire instructions. As soon as we open a file, we are automatically sending the wire instructions through our Qualia portal. So we make sure that happens as soon as possible um, to the client. So let's look at this chart and what's happening. I think the most important thing on the front end is making sure that a contract is received. Once you send over the contract to me, you'll also want to CC your processor. Um, and if you haven't worked with Universal Title before, I will assign a processor for you to work with and make sure that works and fits. I'll be honest, they do most of the work on the back end. They are doing the day-to-day on the file. As the attorney, I am here to support. I am here to answer questions, but I'm usually dealing with issues, problems, title things that need to be conveyed. Whereas our title processor is the person who's like working with the lender, working with the HOA, doing the scheduling, sending wire instructions 95% of the time. And this is true for almost any title company that you work with. Uh, the processor is going to be your main point of contact, and then the attorney is there to support. I'll be honest, I'm a little bit more hands-on than some of the other attorneys at other title companies, and that's just how I like to run my office. You have a direct line to me. Some title companies kind of put the attorneys kind of behind a wall. They don't really know what's going on with any file. They just show up, do the closing, smile, and look pretty. I'm pretty involved and usually know what's going on with your files, especially if there's a problem, and I've helped us solve the problem. So, starting here, number one, send us the contract, include your processor. And I will say, if you're not in the practice of doing this, you should do it right away. When you send the contract, of a lot of agents like to have a cover sheet that they send to the buyer that's like, here's a quick summary of deadlines and timelines for your transaction. I'm connecting you with Joe Bruno, as well as the title processor. They're going to get you their earnest money deposit instructions as soon as possible. And it's just a high level overview with contact information. That is one of the best things you can do to make sure things go smoothly because I can't send the buyer their earnest money instructions until I have an email. And there's not well, there is now, but in the GCAR contract, you can put the buyer email, but in the NVAR or the um, MR contract, there's no space necessarily for the email, so then I have to chase you down for it or wait till you fill out your quality request. So if you want to make sure things are running smoothly, best thing to do is contact info and let us know what's the best way to contact your client. Are they going to not respond to any emails? Because if that's the case, let us know and we'll make sure we communicate with them in a way that works for them. Now, I think it is helpful to have a conversation with your clients of like, hey, look, you're buying a home. We're about to go under contract. You're going to get a lot of information requests from the title company, from your lender to make sure that we close in a timely manner. You'll want to make sure you keep your eye on your emails, even if it's not a thing you normally do. I will say that is usually one of the biggest things that will cause settlement to get delayed is you have sellers or buyers who are ignoring either me or ignoring the lender. Usually the lender, though, right? Because I've heard things like, "Oh, we're not ready to closing. We're going to have to extend. We're going to have to extend." Which is okay if you have a financing contingency. But then I talk to the lender on the back end and they're like, man, we have to keep chasing down the client to get us the information we need. And that's why we're delaying. But of course, you don't say that out front because you want the financing to stay in place. So as soon as you send us the contract, we are going to send the information request as far as earnest money instructions to the buyers. We'll let them know about Qualia, and we're also going to request from the sellers, like, hey, sellers, is there an HOA? Who's the best contact? And it's probably who they provided in the contract if you've listed that, but not always. We also ask them to ask for any payoffs. And it's just kind of the reality of the situation these days. You used to be able to like take a slower approach because closings wouldn't happen for 30 days, 60 days, but that's just not the reality of the situation anymore. Uh, if it would be helpful, we can send you some templates that we like when we're working with agents or TCs. We'll send it to you guys and use that template, right? But yes, because closings are now happening in, I would say on average 3 weeks, to a month, right? You're not going any further than usually in most situations 30 days because of how fast everything is happening. Everyone's got to be on the ball. The sellers, the buyers, we all do our best to be on the ball. The problem is I can't control like condo associations and HOAs. Sometimes they're the problem, they're the delay, but we'll request what we need from them as soon as we can, as soon as we have that information. But if your seller's not responding to the information request, then we're getting delayed there. And then we have to go to the condo after we get the information. So we do our best. We send emails. If they haven't responded, we're going to give them a call. But just having everyone stay on top of their communications is like number one key to success, which sounds cheesy, but it's the truth. All right, so that is all happening in week one. We're getting everyone's information. We're submitting our title order and ordering payoffs or any information we need. Week two, it takes about a week, maybe 10 days to get the title abstract back. The title abstract is the legal history of the property. It tells us every single owner in the last 60 years, every buyer, every seller, every loan that has been filed against a property, every loan that has been paid off against the property. So that's our job to go through that and figure out what issues, if any, are there. The most common thing we're going to see is, hey, we have a payoff that we need to get from a seller. Although we have a lot of unsecured properties right now as well, but that's what we're working on. And as soon as we've completed the title review, then we are sending out emails to buyers as well as the sellers that says, here's the title commitment. Here's what we found when we reviewed the title. For the sellers, here's the issues. We might need your help resolving this, or there's one payoff you've already given this, nothing else you need to do. For the buyers, it's, hey, this is what we found. We're working with the seller, so we're ready to go to closing. That's what that looks like. We're also sending the title commitment to the lender because the lender needs the title commitment as well. And they'll ask us if they have any questions on the commitment or they need weird endorsements. We're not going to get into that today. And then we're also, depending on the time frame, but it's about week 2, maybe week 3, universal title as part of our standard practice when you work with us is you are going to get a draft Alta 10 days before settlement. Not every title company does this. I know they don't, but we have made it a point and a point of pride and emphasis that we will send you a draft Alta prior to closing with enough time for you to take a look at it. And one, especially these days, make sure your commission is correct. Make sure your admin fee is correct if you have one. Those are really important for you guys. I want to make sure you get paid, so make sure they're correct. Yes, we use Qualia, and yes, you put that information into Qualia, but sometimes it just doesn't get inputted correctly, or maybe you miss the admin fee. It happens, right? So look at the draft Alta and make sure your numbers are correct, because if you tell any title company after you've looked at Alta, hey, add this, and they don't, that's on them. I guarantee most of them are going to fix that error quickly, or they're going to just say, you know what, we missed the admin fee. I guess we're going to cover that one. So make sure you're looking for these things. We'll do another class, maybe some other time on Alta and more in-depth nuance there, but important for the draft Alta to come out. Week 3, but sometimes 4 is when we're going to start scheduling. We're going to start reaching out to your sellers. Hey, sellers, settlement is coming up. We would like to get you signed. Usually these days, 1 or 2 days in advance of the buyers. Things are different again. You don't have buyers and sellers usually sitting at the table at the same time signing documents together. Usually sellers are signing in advance. It is one less thing to worry about on the day of settlement. And if it's been a tough settlement, we don't need parties who have maybe been butting heads a little bit in the same room together. Just been there. It's not fun for anyone. Um, so we do it that way to have the seller sign in advance. Sellers these days, 95% of the time, they can sign via what's called remote online notarization. They can sign electronically. Now, it's not like DocuSign, but it's closer to a Zoom call through our Notary Cam platform where they've got to be on camera. They have to be on camera, have a microphone, and be somewhat decent with technology. If you have an older client and they have an at AOL.com email address, maybe they're not a great candidate. And that's not always true, but maybe they're not a great candidate for an online signing. If you have to go over and hand deliver documents for them to sign because they don't do technology, let's not give them a remote online notarization option. Let's have them come into the office. Right. But for many clients who are overseas, out of the state, maybe they're moving in, for sellers, online is a great option. I'd say about 40% of my sellers are signing via remote online notarization these days. And I will do my closings for my clients a lot of the time. So you still have an attorney there. You, as the agent, we send you a link. You can join as well, but you don't necessarily have to. You know your clients better than we do, and if they need you there or not on the seller side. Buyer side, you're probably still having buyers come in to sign documents in person unless it's a cash deal at Universal Title. If you have clients who are buyers in California, fine. We can send documents to California. They'll sign them there, get them notarized, and send them back to us. We can make those additional accommodations, but there's a fee. Leading up to the settlement, as soon, and this is an important, I think, part for you guys as agents to understand, is big question we get from the buyers is what's my final number? What's my final number? What's my cash to close, right? At Universal Title, we will provide it as soon as we have it, but oftentimes we're doing what's called balancing with the lender, which means finalizing the numbers. I find that what gets confusing or a common confusion point is when the lender says, hey, we're clear to close. And it's true for some lenders, but not all. Some buyers hear that and they're like, all right, let's go to the title company and sign documents. And that's not necessarily the case. You can still be clear to close, but it's still going to be 1, 2, 3 days before you're actually going to be sitting at a closing table that is fully dependent on the lender and what their workflow looks like from clear to close to, yeah, we can go to settlement now. The thing that is happening is 3 days before closing, regardless of lender, your buyers are going to get a CD that is a close idea of their cash to close, but it's not their final idea of cash to close. While some numbers aren't able to change at that point, some can. Uh, so important to set that expectation, I guess, with clients if they ask you about it, like, oh, is that my final number? You got the prelim CD? Not necessarily. Check with your lender. Always check with the lender. Hey, is this our final number? Or check with us and we'll tell you, yes, it is, or no, we're still balanced with the lender. We try to get the final cash to close number at least a day or two in advance, but that's just not always the case depending on the lender and who we're working with. I just had a Navy Federal deal closed today. They got us the final number 10 minutes before settlement. Not a fun situation, but in that we tell your buyers, hey, we're pretty sure your final cash to close number is about this much. Why don't you wire in an extra $500,000 to account for any minute changes that might occur? So that can happen. It depends on the lender and it depends on the title company you're working with. Some other things that I've had come up as far as leading up to settlement. One, buyers need to make sure that they know how they're going to wire funds to us as the title company. That is our job, and we do let the buyers know, hey, you need to check with your bank, make sure you know how you're getting your wire to us. I just had a buyer who was using a really weird bank that I'd never heard of before because they offered a high interest rate on like a savings account, but they could only wire $50,000 a day. And guess what? They had to bring $200,000 to settlement. So we had to extend settlement 3 days for them to send four different wires on Monday, Tuesday, Wednesday, Thursday, and then close on Friday. And again, the information is given to them. Hey, please check with your bank. What are their policies when it comes to sending wires? Um, but it doesn't always happen. So as many people as we can have to help reiterate that point is helpful for making sure things go smoothly. Uh, as far as final walkthrough issues that come up, and I think I skipped. Oh, that's fine. I think I skipped some points there, but as far as the final walkthrough, I usually recommend you do it the day before or the morning of. I know oftentimes agents like to do the final walkthrough and head directly to the title office. Pros and cons there. Pros, the home's in good condition right before settlement. There's no chance anything happened overnight. Cons, if there is a problem, now we're scrambling to fix the problem and probably pushing settlement back. So if you can build in some buffer time to kind of solve any issues, whether it's, hey, there's still trash here, sellers, what are you going to do about that? I don't want that fridge, or I don't want that sofa you hopefully left behind, right? Smaller minor issues, right? Get a solution in place by the time we're signing documents. Or if you have a bigger issue where you're like, there appears to be a leak on the ceiling. What is that? Do we have time to get a contractor in there to get a quote? I know oftentimes agents like to immediately turn to an escrow, which is, hey, why doesn't the title company just hold $5,000 while we figure out how to solve this problem? That is becoming less and less of a thing. It's sometimes a thing, but less and less of a thing because one, lenders will frequently say no, even though it's on the seller side. They don't want to see the word escrow anywhere on the settlement statement these days. So that means your option is to pay an invoice, which if your invoice happens to look more like a quote than an invoice, I can kind of check for what the quote is from the contractor you've hired to help solve the problem or ballpark it for you. But the problem is if it's a really significant issue, and that quote is wrong and we've undercollected, there's nothing I can do. So whenever possible to either delay the settlement or get a really good idea of what it's going to cost, I recommend you do that rather than immediately turn to the escrow. But you can call me and ask me about it and I'll give you some recommendations of how we move forward in that situation. Uh, any questions on all of that before I go ahead and turn to our next slide? All right. I'll keep moving forward. General reminders. This is important for you as agents. You should all know this. Or let me rephrase. You should all know where to find this information, and that is what are the deadlines for the different contracts you're going to be working on, right? Under the GCAR contract, the deadline for most times to act is 6 p.m. Under the NVAR contract, the deadline to act is 9 p.m. Under the MR/MAR contract, the deadline is midnight. I remember it because G looks like a 6. So, okay, G car, it's a 6, it's 6 p.m. deadline. NVAR 9 starts with N, NVAR starts with N, so NVAR means 9, and then MAR. The MAR contract starts with an M, midnight is an M. That's how I remember this. Helpful tricks I've come up with to memorize the deadlines. That being said, there are a couple items that don't follow this that can be specific, but hopefully that somewhat helps. Good rule of thumb, usually. Important inspections or important deadlines, EMD home inspection. So let's start with the EMD. This does come up as a common contract complication I find is that, especially in the MR contract, more so than the GCAR contract or the NVAR contract, but the earnest money deposit, the contract very specifically says when the earnest money deposit is given to the title company can do four things. We can credit it towards the sale price at settlement, assuming we go to closing and everything's fine and there's no problems. The second thing is all parties agree that Universal Title should do something else to the earnest money deposit, meaning if like the contract voided, everyone signs a release. Otherwise, a court of competent jurisdiction orders disbursement, meaning if there's a disagreement on what has happened as part of the contract and there's a breach, then a court will tell us what to do. Uh, this does not allow Universal Title to release an earnest money deposit if it was a unilateral release used to release the contract. So if you send me a unilateral release that says send the funds back to the buyer and I don't have a signature from the seller, there's nothing I can do, even if it is obvious, bright as day, clear as not. It's just very clear that the seller was the one who breached the contract. It does not matter. I cannot be the person who is the fact finder in these types of scenarios. We're not allowed to be. So I can do one of those three things, but I cannot unilaterally release an earnest money deposit except in one scenario that I'll tell you about right now. And that is if upfront on the very front end of a contract, if the parties have both agreed that if closing does not take place by a certain time and that earnest money deposit is non-refundable, sometimes happens, sometimes point of negotiation is non-refundable, and that Universal Title is instructed to convey those funds to the sellers regardless of any issue, then I can do it. So that kind of falls under two, though, that both parties have agreed that if settlement doesn't take place on August 30th, all earnest money deposit goes to the seller, right? If they agreed to that, then I can do that. But short of a very clear direction stating something to that effect, I can't make my own decisions, right? And again, I'm just doing what you told me. I'm not making a fact-finding basis in this scenario. The other thing, yeah, I already mentioned all this. Buyer backs out of the contract based on a legitimate contingency. They're entitled to get their earnest money deposit back. Seller must sign the release. Are most of you guys doing Maryland transactions, I would imagine, for the most part, or DC? Yes, I'm seeing yes. Okay. The reason I'm bringing that up, especially with Maryland, is Maryland has provisions related to mediation, which are really important to know should there be a conflict and a dispute and we don't close on time. It puts a lot of onus on the buyers for if there's a dispute over the earnest money deposit, well, buyers and sellers, if there's a dispute over the earnest money deposit, one or both of the parties needs to submit a written request for mediation, disputing the funds. Otherwise, there's a chance Universal Title can now disperse the funds back to the buyer. But that means the buyer needs to follow the directions to make that happen. It's very technical, and the seller needs to follow those directions. We're not going to go over it now, but if you are in a situation where there's a dispute over an earnest money deposit and a breach of contract, review very carefully your mediation paragraph at the end of the MR contract that says these are the steps you have to follow and the timelines in which you have to do it. And then once you've reviewed those, call me and we'll go through it together. Review it first and then call me and we'll look at it and make sure you're following the steps. Because if you don't, we get stuck in like this weird land where I keep holding on to money I don't want to hold on because someone didn't follow their procedure and they want the money back. It's not a fun position to be in for anybody. And then you as the agent also not having a great time still having to work on a deal that's never going to close. All right, HOAs and condos, these are your deadlines. Okay, super relevant story, so pay attention here if you guys aren't. HOA and condos, everyone knows this, that you have certain days to cancel based on an HOA or based on a condo. I had an agent go under contract with a buyer. Um, they submitted their earnest money deposit and for some reason, they signed, and the very next day, the buyer got cold feet. Uh, the agent and for the buyer, and I understand what they were trying to do. They were just trying to be upfront, honest, like, let's just get things moving along here. The buyer's agent told the seller's agent, hey, my buyer got cold feet. Let's just void the contract and move on. We still have the HOA and home inspection to get out of the contract on, anyways. That's not a good idea. Uh, you have to, as a buyer, act in good faith. You can't just get cold feet. I mean, it happens all the time, and everyone knows that you have this, and the agent knows that you have this. You do have a right to cancel after the HOA or the condo docs have been received. But, and again, it's a little bit of a game and it's a little bit silly, but don't tell the sellers you got cold feet. That's why we're canceling. Don't lie off either, but just say, hey, we got the condo docs and we're going to void the contract based on that. Uh, the reason the buyer's agent did what they did is they were trying to keep things moving along, expedite things. Why make them wait 3 days for the HOA, your condo docs to be received? I'll tell you right now. Now there is an argument, I guess you could void under the condo before even seeing the condo. I don't know what courts think about that or say about that. So I would just wait for the condo docs to come in and then void the contract because that is a right you have as a buyer. Does that make sense to everyone? Because the argument on the listing side is like, hey, you told me you're not voiding because of the condo. You told me because you got cold feet, which is not a valid out under the contract. So hopefully this one doesn't go too far. We'll see what happens, but it is a can of worms that the buyer's agent is now dealing with. Not a KW agent, so that's a good thing. But something to keep in mind there.
Excuse me, Joe. Could you repeat this, the last one, the last thing that you say
About which part?
about the condo, the client that withdrew from the condo that signed? Because I want to hear it well. So
Right.
he had a cold food feet, and then he
So
requested.
yes. So we were in a situation, I'll repeat it quickly, and then we can talk more, Marie, if you come into the office sometime this week or next. Um, we had a situation, buyer went under contract. They had a condo documents that were going to be sent over, and they had a home inspection contingency to void only. The buyers, the very next day before any of the clocks started ticking, got cold feet, and the buyer's agent said, hey, my buyer's going to back out of contract. They got cold feet. And they put that in writing and in an email. That is not the proper way to exercise your rights to void a contract under a home inspection or under the condo doc rights to void the contract. Because you as a buyer do need to act in good faith, and they very clearly put in writing like, oh, he's not really voiding because of the condo, he's not really voiding because of a home inspection, he just doesn't want to buy the home anymore, right? That's not what the contract necessarily allows. So they should have properly exercised the right to void following either the HOA or the condo and sent over the notice, hey, we got the condo docs, we're going to void the contract. Again, you have to pay attention to your deadlines and your timelines to make sure you're exercising those rights properly. And you want to do that in writing. So, Marie, we can talk about that more, but you do have a right to void, and it wasn't used properly, and it's created a bunch of problems for this buyer, the buyer's agent, and the sellers.
Thank you very much, Joe.
Of course, you're welcome. Yeah, I can send this slide deck to you. Uh, title.
Joe, if
So,
you send it to me, I can put it with the recording when I post the recording.
yeah, let's do it that way.
Okay, that's easier. All right, cool. Thanks.
Good. This is important in a situation that's coming up right now. I had a DC contract. Um, DC contract, and under the DC contract, there's a paragraph that says if there's a title problem, there's a 30-day extension. If the title company decides the property's not in the required discretion. So it puts the onus on me to be able to say, hey, we're not ready for closing for a title issue. So we had closing scheduled for, I'm just going to make this a hypothetical, but it happened. We had closing, let's say hypothetically scheduled for April 30th, leading up to settlement on the 28th, 29th. We find out there's a title issue, there was a tenant issue, TOPA we need to address. And the sellers and the listing agent thought, well, if we're not ready to close by the closing date because of the title issue, we're out of contract anyways, and we can just go back on market, right? And they're like, and that's what they asked. And I had to remind them that no, if we have a title issue and the title issue is the reason we're not closing, the contract says it's a 30-day extension. So don't just assume you're out of contract because you missed the original closing deadline. There very well could be a built-in extension into your contract depending on what that issue is. So you have to review the contracts when you don't close on time to figure out what happens next, is the point I'm trying to drive home there. NVAR handles this differently. It is not a 30-day extension, and MR handles it differently. It is not an automatic 30-day extension. Again, it's quite technical, and you want to review it. Even as an attorney who deals with these contracts every day, whenever I'm going to talk about the contract, I have it right in front of me to review. So I suggest you take the same approach whenever you're trying to answer a question about the contract or what should happen. Make sure that contract's in front of you first before you even take a stab and try to memorize something, especially if you work in multiple jurisdictions. All right. Walkthrough. I'm going to skip past the walkthrough. We already talked about that scroll already. Funds for settlement, we talked about already. Wires, cashier's checks. I'll mention this part. This is a new practice, and I probably should update the slides, but many title companies these days, if your closing costs for the buyer is over a certain amount, they're not going to be able to bring a cashier's check to closing anymore. The title company is going to require their final cash to close is wired in. This is problematic because truthfully, at UT and other title companies, we scare the crap out of your buyers to make sure they don't fall victims to wire fraud. So then they're like, well, I don't want to send a wire. You scared me with all this stuff about wire fraud. Um, which is kind of like, I don't know, pros and cons in this type of scenario. So yes, wire fraud is a thing. Yes, every single email at Universal Title and most other companies at the bottom of their email say, hey, we are never going to email you wiring instructions. We are never going to change our wiring instructions right before settlement or leading up to settlement. We won't do that. If someone is emailing you saying, hey, we're changing our wiring instructions, I'm so sorry, that should be an immediate red flag for either you as the agent or for the buyer. Qualia, and most title companies use Qualia now, sends out this video at the beginning of the transaction that says, hey, this is what wire fraud is. This is how it works. This is how you prevent it from happening. So we try to make it look like, yes, this is the thing you should be alert for, but here's how you make sure that it's not a problem. You call the title company from a secure number and verify the wiring instructions in advance. So you do probably have to, if you get the question from your buyers, again, it's our job, but they're going to ask you because they trust you. Hey, I want to bring a cashier's check. Is that okay? Right? Check with the title company, see if it's going to be okay or not. If it's over a certain amount at Universal Title, it's roughly $2,000. I'm going to require and tell people, hey, you have to bring in you have to send a wire, which means you need to go to your bank, tell them you want to send a wire, and why don't I resend you our wiring instructions through our secure Qualia portal is what that usually looks like. There can be exceptions, but you got to talk to us in advance. Reason the cashier's checks is problematic these days is cashier's checks can be fraudulent. We've had fraudulent cashier's checks come through our doors, which is why we're very hesitant. If someone needs to bring a cashier's check for a large amount, $10,000, $15,000, then we are going to call the bank that issued and have them verify that this is a real legitimate cashier's check that they have issued. This becomes a problem if it's 3 or 4 o'clock and your bank's not picking up the phone and I can't verify if I have certified funds in my hand or not. And then the seller's not happy because the buyer was supposed to get certified funds in our hands and I can't verify it's true. And then there's a delay in getting a wire out. So that's what that looks like. If it's a large amount, usually over $2,000, your client needs to send a wire. If it's three or four, maybe a cashier check's fine if we can verify it. We can allow personal checks for lower amounts, $1,000, $500, $50. Personal check is fine. I don't need certified funds for that, but most people don't have personal checks these days, is my experience. Good. Where are we? Are we until 1 o'clock,
Um,
roughly, or
well, no, but we have another session at once. We definitely have to end before then.
okay, that's fine.
Yeah. Joe had a question.
Hey Joe. So going back to the cashier's check versus wiring, say if the client is absolutely uncomfortable with the whole wiring thing and they just want to do cashier's check, is there a way we can preempt the delay by sort of like scheduling the time in such a way that the cashier, like, maybe meet in the morning, or like, is that something that the agents typically do when the seller or when the buyer is
Right.
insisting that they want to do
Right.
cashier's check?
If you call me, you're like, hey Joe, my guys really don't want to send a wire. They're super nervous about it because of all the stuff with wire fraud. It's like, well, let me have a conversation with them and see if I can maybe get them comfortable with it and make sure to walk them through it and how we can make this as easy as possible for them, right?
Mm-hmm. Mm-hmm.
Usually I'm successful at that, but not always. And in the cases where I'm not, it really depends on what is the amount we are looking at. If this is a cash deal and there's no loan and they have to bring me $1 million, I'm not going to accept $1 million cashiers. I'm just not. And I'm so sorry, but if you want to close this is the only way. If it was $1 million transaction, I'll go with you to the bank and let's just get this done. Right? And make sure they feel very comfortable. So the extremes I'm willing to do to make everyone comfortable with what I was, as long as I'm able to. Uh, but if it's a smaller amount, 10,000, 20,000, even up to like 100,000, what I can do is fine, let's work with your lender. Let's get a final cash to close number as soon as possible, hopefully 2 or 3 days before closing.
Mm-hmm.
Go to the bank, get me the cashier's check, bring it to me 3 days before we close. And then get me a contact person over at that bank. Like, tell me which bank you went to so I can call that person and verify the check. The real problem comes when I don't have a means to verify a check because no one's picking up the phone.
Got it.
Some of the larger banks, Wells Fargo, Chase, you can actually just put the cashier's check into a system they have and it'll say, yes, this is verified. But many banks have not gotten on board with that. And again, I had this last month where no one at the bank would pick up the phone for 2 days for me to verify the check, and the seller's getting really frustrated. They don't have funds yet.
Mm.
So that's why we try to avoid the certified check. And you have to go to the bank anyways to get a cashier's check. So to the point you're already there, why don't you hand the bank our wiring instructions that you've downloaded through the secure portal, right? And I've even had people like, hey, you're really nervous. You don't want to like mess this up. Why don't you stop by my office? I will print out our wiring instructions and you will hand that to the person at the bank so they know what to do with it. And that usually gets them over the hump.
Got it. Okay, cool. Thank you.
It's a really good question because it's a thing, especially with older clients, they're used to doing it a certain way and things have changed, and that's just how it is. Good. We talked about the difference between clear to close and how that's a little bit variable of when that means you can actually close. We talked about wiring instructions being set up. I've even already talked about closings already for us on the front end. I do like there's a lot of lenders doing what's called a hybrid closing, where the buyers will sign a majority of their documents upfront online, and then they're just signing a package of 10 or 15 documents when they come into closing. That's everything that needs notarization. That makes things go pretty fast. Uh, Powers of attorneys, let's talk about that really quickly. If you have situations where your buyers in particular can't attend the closing, Universal Title will draft power of attorneys for your clients in advance for them to authorize someone else to sign on their behalf. Usually a lender will always have to approve a power of attorney, and you as the agent can't be it. It has to be like a neutral party, usually a family member. Uh, These can sometimes be signed via remote online notarization. I had some buyers who were over in Thailand and we needed to get one done, so I took care of that for them yesterday. That is a helpful tool to know if we have situations where someone can't be present for a closing. Uh, and I think that's fine. You know what? I've got 5 more minutes. Let's run through these scenarios because these are really important mistakes that happen. One, if you are working with foreign sellers, that's important to know. Foreign sellers are subject to what's called FIRPTA. So if you, and for us, the question I ask and the question you can ask, because it can be a sensitive topic, is like, oh, are you a citizen or green card holder? Asking for tax purposes, right? And they're supposed to disclose that in the listing agreement. It doesn't always happen. If you find out or if you have an inkling like, oh, they might not be US citizens or they're visa holders, I don't know what their situation is, right? Why don't you bring it? Call me. We'll figure it out. We'll get it done beforehand. It is important because if FERPTA applies, it's 10 to 15% of the purchase price, which I've had a $2 million transaction fall apart because that was $300,000 in taxes that needed to be withheld. Sellers were not prepared for that. It was a shocking surprise to them. So if you are working with foreign clients, talk to us. Let's figure it out. Let's do it in advance. Non-resident withholding. For you guys doing Maryland, pay attention to this one because this one does get missed.
Joe, sorry.
Yeah.
I didn't want to, I know you said to jump in and cut you off,
Yeah, go ahead.
but as far as the foreign clients, when do you want us to kind of start to talk to you? When we're looking at homes, or as soon as I first have them sign the agreement, I reach out to you, hey, this is where we are. How do you like it?
Do it on the front end. Like the sooner the better. Like just so we know what to prepare, and that way you can have an expectations conversation with your client sooner rather than later. So there's
So,
so it is much easier for me to help you if we have weeks rather than 2 days before closing. Hey, I was working with a client and they mentioned this, right?
okay, okay,
Uh
okay. Thank
we
you, Kirsten.
Yeah,
Because
it's a
she
good
mentioned
question.
that to me, and I'm going through that now. So you and I will talk.
Yeah, let's talk about it. What I will say, again, title company using Qualia, we do ask clients as an automatic request, what is your citizenship status, right? And we get immediate flags if the answer is non-resident or non-resident alien. Now, if they're a resident alien, a green card holder, they're fine. There's no FERPTA for green card holders. But once you move outside of US citizen or green card holder, a resident alien, that's where FERPTA conversation becomes very real. So the sooner you bring me in, the sooner we can tease out what needs to be done. Maryland non-resident. I'll finish on this one. And I'm going to do this in reverse, but at closing, your client selling Maryland property will have to sign a piece of paper that says either I'm a Maryland resident or I'm not a Maryland resident, but the home was my primary resident for 2 of the last 5 years and it was registered as such on SDAT. If your client cannot sign the piece of paper that says I'm a Maryland resident or I was a Maryland resident, I lived in the home as a primary residence 2 of the last 5 years, they are going to probably be subject to a 8.75 tax withholding on their net. This is not a welcome surprise to come up at the settlement table. So if you're working with clients who are in Florida, that should be not a red flag, but a yellow flag that we need to figure this out. Because again, it's not a good situation to have to tell a seller at the closing table in front of their agent that, hey, I'm so sorry, but I actually need to collect an extra $30,000 from you because you are not a current Maryland resident or you're not registered such. I've had to do that more times than I would like. It's not a happy situation for anyone, even though I can say, well, the contract mentions it right here. Or like you said right here when you signed the listing agreement, it doesn't apply. It doesn't matter. They're still going to be upset, right? Um, this is a thing to look out for, and you don't want to get caught in this trap. So if you have some reason to believe they might not be a current Maryland resident or something weird's going on with their residency status, try and tease that out. They do make it pretty clear what the criteria are on the listing agreement and on the um, contract itself. And the reason, and this is how I think you provide real value from like a contract perspective as a real estate agent, is there can be situations where one of those two criteria I mentioned are not true. And then they can still get an exemption if they apply 21 days in advance with the comptroller. If they don't apply 21 days in advance, I still have to collect, even though we shouldn't have. So those types of situations where they can get an exemption, but they need to apply in advance are going to be, let's say you have husband, wife on title, and so is their parent who lives in Florida. I had to do this once where these two, they're Maryland residents. The third person lives in Florida. They were just like on the loan to help, but they live in Florida. Well, they can't sign they're a Maryland resident and they can't say that they lived in the home as a primary. So I have to collect 8.75 of a third of the proceeds. But if we had applied in advance, that person can say, hey, I'm not getting any proceeds from the sale. I'm not subject to this withholding, and that will get approved by the comptroller. Yes, it is a tax issue. Yes, clients should talk to a CPA. Are they going to do it? Probably not. So this is why you as the agent kind of have to be on guard for these types of scenarios, and you provide support, which is like, hey, there's this form we could submit the comptroller to make sure we don't get hit with an additional non-resident withholding. So those types of scenarios are going to
Yeah.
be like, yes, one second, I'll get to that. Is I'm not a non-resident, or the other scenarios can be like it's a 1031 exchange, or it was a primary, it's just not registered anymore. There are those scenarios in place. And again, if you have questions about this, you think it might apply, talk to me and we'll figure it out. Joe, I had a question.
Hi, sorry, this is Dana Hall.
Oh, Dana
Yeah, I
Hall, go
wanted
ahead.
to just wanted to ask like how far ahead you can do that and it does it, people who selling their house and moving out of state and or buying a house out of state and then selling their Maryland residence
Yeah.
after they move, this is obviously something they would want to do. Do you feel like 21 days is enough, or is that something can they even apply to do that while they're still living in the home to make sure that's done? That kind of a thing.
Right. So the starting point is like, do they even need to? Because if they can say, and this applies to a lot of people who just moved to Florida, they're probably going to be able to say that I'm not a Maryland resident, but it was my primary for 2 of the last 5 years, and it's registered on SDAT. They probably don't need to do anything. But as far as the 21 days, you can't apply with a comptroller typically until you're under contract. If you have a
Oh,
14-day contract, that's a problem. So,
okay.
and
Okay, good to know.
there maybe you can convince the comptroller to take an advance depending on the reason for exemption.
Okay,
One other exemption that you see is, hey, I'm in the military. I did live here as a primary residence, but I'm still registered in Texas, but I'm in the military. Like that's also an exemption that people can apply for. Uh,
great. Thank you.
Good
Joe,
question.
how quickly, when is like an ideal time for us to introduce our clients to you so we can flush out any of these issues that may happen, and not wait until closing to come up, kind of figure out, oh my God, this is another issue we have to deal with. So when
Right.
do you think we should actually introduce them, or is there like an ongoing conversation that you and the agent should be having about the clients you're working with?
Right. So I would say bring me in when you think there might be a problem. I obviously can't work with every client beforehand on every single time. You're right. I would love to. But if you're like, I think I have a problem, but I'm not sure about it.
Hmm.
Good, bring me in. Send me the email. I'll take a
Okay.
look at it. But it also depends on the contract length. Like a lot of this stuff does get, well, a lot of this stuff should be getting teased out when you are going through the contract with your client. And if you're like,
Mhm.
I don't know how to fill out this part of the contract, or I don't know if it applies or not, that is a good opportunity to bring us in right there.
Okay.
But we also tease this stuff as part of our job. Like as soon as you send us the contract, we're gonna do this. I am gonna check. I'm gonna be like, do I need to collect a non-resident withholding? Do I need to maybe ask somebody about it? We do that as part of the contract opening as well. But the sooner you can avoid an issue, the better you look for your clients.
Okay. Got it. Cool. Thank you.
Good. All right. Apparently, I've only got 6 minutes left. So, are there any last minute questions before we all hop off here?
Yes, yes. You said green card holders are exempt from the tax,
Correct.
the F something, something.
The FERPTA, yes.
Yes. Okay. Okay. Okay.
So
Okay.
if
I'm
your
literally
guys are
looking
green
for a
card
house for him right
holders
now.
or resident aliens is the official designation, but everyone calls it green card holders. they are very likely exempt, especially if they've been living in the US for some time.
Okay.
Yeah.
So anyone on H-1B or F-1, if they want to buy a house, they are the ones who we need to flag and bring them to you.
Well, there's no
Or
problem. So it depends. There's no problem buying a house. You can buy a house. There's no problems there. The problem is when you go to sell the house, right?
Mhm.
That's where it might come
Yes,
into
okay,
play.
yeah.
Now, you can try to set your clients up for success early on, right? In this process when they buy, so they know what it looks like if they're going to sell, but it depends on their situation. If someone was buying a $3 million home in Bethesda or McLean and they were non-citizens, I would certainly refer them like, hey, why don't we get all the professionals involved at the very beginning from when you buy this property so you know exactly how you're going to manage your assets when you sell the property,
Okay,
right?
okay.
In that type of scenario. Cool. Otherwise, one, thank you guys for the questions. I really appreciate it. And thank you guys who are on camera. I really appreciate that as well. Hopefully this was helpful. I'll send the slides out. That way you guys have them for review.
Thank you so much for today. I think you provided a ton of value, don't you think, guys? And did you get a lot out of this?
Much
Yeah, we
needed, Joe.
did.
I'll
Yes,
be
yes,
talking to
Yeah,
you.
for
We'll be
Thank you
sure.
so
talking
For
much.
shortly.
sure.
yeah,
Thank you, Joe.
Yeah.
yeah.
You guys,
And then
Yeah.
I'll put their contact info and the slides and everything when I upload the recording. Just go to the comments. I'll have more stuff below it. Somewhere I'll have it attached or something like that so that everybody can get it. And for anybody watching the recording later.
cool.
Thank you
This was
so
great.
much.
Thank you.
All right,
Thanks, Joe.
Everyone.
buddy.
Thank you.
See
Thank
you
you, Joe.
guys at 1 o'clock for that important update meeting. Okay, it's a different Zoom, so you're going to log out and back into the other Zoom that just got texted to y'all. All right,
Hmm.
bye everybody.
Great.
Thank
Bye,
you.
guys.
Thanks so much,
Thank
Joe.
you.
Bye.